Hello everyone, this is Advocate Akriti Singh, Senior Legal Associate at NRI Legal Services. Today, I am here to apprise you all regarding Succession Certificate and Legal Heirship Certificate. Succession Certificate is a document which is obtained by the successor or inheritor of the deceased person who died without writing a will. In simple words, it is obtained by the successor to own the properties left behind the deceased person. This also authenticates and establishes the successor's right over the property. It may be noted that all the debts and securities can be claimed by the successor via this certificate. For obtaining a succession certificate, it needs to be filed in the territorial jurisdiction. If the jurisdiction is Gujarat, the succession certificate will be filed in Gujarat. It may be noted that the succession certificate will be filed where the deceased was residing at the time of the death. In case of non-availability of any such place, the succession certificate will be filed within the area where any asset of the deceased would belong. Now we will discuss the procedure involved for the succession certificate. Step 1 is petition preparation. The counsel or the representative will prepare the succession certificate application, which will be filed before the court of law along with the requisite stamp and court fees. The second step is hearing. Once the succession certificate is submitted before the court, the honorable judge will hear the counsel and the relevant facts will be projected before them. Thereafter, the summons and notices will be issued to the opposite parties. Simultaneously, public notice is also issued in the local newspaper, and then the court waits for stipulated period of time to receive objections, if any. Step number 3 is evidence. Thereafter, the petitioner files the written and oral submission of the evidence. And lastly, the grant of succession. Once all the requisite steps are completed, the court decides whether the claimant has a right to obtain the succession certificate or not. Now we will discuss the particulars and documents required for succession certificate. Firstly, place, date and time of the death of the deceased along with the original death certificate. Secondly, all the bank paperwork such as passbooks, fixed deposits, etc. Next, all the details pertaining to the debts and securities. And along with this, the details of the family members or legal heirs, that is their names, addresses, along with their identity proofs. Now I will discuss succession certificate and wills. In case a will is left behind by the deceased person, then the succession certificate will not be granted. The beneficiary of the will definitely inherit the properties according to the instructions provided in the will. Although, as per the section 370 of the Indian Succession Act 1925, a succession certificate will not be granted with regards to the debts and securities in case the right of the property is meant to be established by getting letter of probate or administration. It may be noted that the rules pertaining to the letters of administration is different in each state. However, if there is no will, then the banks, financial institution and other organizations will definitely rely upon the legal heirship certificate or succession certificate. Now we will discuss legal heirship certificate. In case of untimely demise of the loved one, it is important to obtain a legal heirship certificate. Before filing this certificate, one needs to have an original death certificate of the deceased, which can be obtained from the municipal corporation. It is important for the NRIs to obtain the legal heirship certificates to inherit the properties situated in India. It is important to know the purpose and benefits of the legal heirship certificate. Firstly, it will help to inherit the properties of the deceased person. Secondly, to claim the insurance money. Thirdly, to avail the arrears of salary in case the deceased was employee of central or state government. Fourthly, to receive the funds such as provident funds and gratuity. And lastly, to get a compassionate job of the deceased person. Now, who all can apply a legal heirship certificate? Firstly, the deceased spouse can apply for a legal heirship certificate. Then, children of the deceased, maybe son or daughter, and then parents of the deceased. Procedure of legal heirship certificate. A legal heirship certificate can be obtained from a municipal corporation, Taluk Tehsildar office, or even district court. It is important to note here that the legal heirship certificate and its process varies from state to state in India. While obtaining a legal heirship certificate, one needs to fill the requisite form, and the same needs to be annexed with an affidavit which has to be signed, verified, and notarized. The application will entail the details pertaining to the deceased along with the legal heirs. There will be date, place of the deceased along with the original death certificate. There will be also the details of the legal heirs, including their names, age, addresses, along with their relevant identity proofs. Once all the documents are submitted before the authority, the concerned official will scrutinize all the documents, and then the legal heirship certificate will be granted within the stipulated period of time. Now, what is the difference between succession certificate and legal heirship certificate? Most of the people think that both are similar. However, they are totally different. The succession certificate is issued to obtain the assets, that is debts and security of the deceased person. However, legal heirship certificate is crucial to obtain the certificate which depicts the relationship with the deceased and authenticates the successor and inheritors, so that they can claim the properties of the deceased in future in any of the concerned department. Now we will discuss the revocation of the succession certificate. A grant of a succession certificate can be revoked under Section 382 and 383 of Indian Succession Act if the proceedings of the succession certificates were found to be defective. Defective means if the proceedings had some sort of harm and prejudice to any third party. Also, if there is any concealment of the relevant fact, then such certificate will be revoked. Similarly, a legal heirship certificate can also be revoked under Section 2 of the Bombay Regulation Act, where there is non-disclosure of a certain fact. Both succession certificate and legal heirship certificate has its own benefits and importance while claiming the assets and properties of the deceased. Most importantly, NRIs who are residing outside India may claim the assets left behind their deceased family members via succession certificate or legal heirship certificate. Thank you for watching this video. Please like, share and comment. And in case you have any query, please write us at query@nrilegalservices.com. Thank you.